that this matter be put out maybe 30 days for a chance for Mr. Johnson to get with the friend of the court and see what happened with the job notification, and also to see if there are payments he can make, Your Honor.
All right, I'll grant one adjournment. Given what I've heard, I would be inclined to set this for a hearing at the next pretrial conference on this matter. What I'm concerned with, obviously, is that payments get started regardless of whether or not an income withholding order was sent out. It's Mr. Johnson's obligation to make the payments. So if they weren't getting automatically withhold, it was his obligation to make them himself. But I will grant one enter not guilty plea, grant one adjournment until February 4th at 8:15. But again, I'd be looking to set this for a hearing at that point.
Thank you, Your Honor.
So, Mr. Johnson, your next date is February 4th at 8:15 a.m.
Okay, thanks, Your Honor.
And Mr. Johnson, contact my office. Your number did not work well when I tried it. Okay?
Yes, ma'am. Yes, ma'am. I will contact you.
Thank you.
Thank you.
Okay, Mr. Feifelski, are you ready to proceed with Mr. Federer?
Yes, I am, Your Honor. We have a plea worked out.
All right, this is file 25-22422-FH and 25-22423-FH. People of the State of Michigan versus Jeffrey Allen Federer. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Good morning, Your Honor. James Feifelski on behalf of Jeffrey Federer.
All right, and Mr. Feifelski, where do we stand with Mr. Federer's case today?
Mr. Bayonetto and I have worked out a plea agreement whereby Mr. Federer will plead guilty as charged in case 25-22423-FH and case 25-22422-FH, and the habitual offender supplements would be dismissed. There's also a sentence agreement of no more than 59 days of initial jail, any balance to be suspended but imposed if the defendant violates probation. And I believe I have reviewed the plea agreement form with my client. He did give me permission to sign that for him, and I've submitted that to Mr. Bayonetto and to the court.
Is that a complete and accurate statement of the plea agreement, Mr. Bayonetto?
It is, Your Honor.
Something's going wrong. I have some
Just
guy.
hang on, Mr. Feder. Hang on.
Just wait, sir.
There we
All
go.
right. Mr. Feder, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury.
So help me God, I do.
And you are Jeffrey Allen Federer.
Yes, I am, Your Honor.
Mr. Federer, you include the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 25-22423-FH to count 1, operating while intoxicated?
Yes, sir, it is, Your Honor.
You understand that the maximum possible penalty for that offense is a fine of $500 to $5,000 and either 1 to 5 years of probation with 30 days to 1 year in jail, and 60 to 180 days of community service.
Yes, I do, Your Honor. Yes, sir.
Do you understand that that also requires mandatory vehicle immobilization of not less than a year or more than 3 years?
Yes, I do, Your Honor. Yes, sir.
Are you satisfied with Mr. Fifelski and the advice that he's given you?
100%, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it here today. Is that correct, Mr. Bayonetto?
That's correct, Your Honor.
Mr. Fifelski?
That's correct, Your Honor.
Is that also your understanding, Mr. Federer?
It is. Yes, it is, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Federer, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
I do, Your Honor. Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights I've explained to you?
No, sir. I understand them all, Your Honor.
Do you understand that you're giving those rights up?
I do. Yes, I do, Your Honor.
How do you wish to plead to the charge that on or about April 4th, 2025 in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of operating while intoxicated, third offense?
Guilty, Your Honor.
Has anybody made any threats or promises to you in order to get you to plead guilty to that charge?
No, sir. None at all, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that that plea was given as a result of threats or promises that were not disclosed to court on the record today, or that it was not your own choice to enter that plea?
Yes, I do, Your Honor. Yes, sir.
So you prosecute or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Federer to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Federer, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record here today?
No, sir. Just a plea agreement. Yes, sir.
If your plea is accepted and you engage in misconduct, the court is not bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
All right. Well, 100%, Your Honor.
Is it your own choice to plead guilty today?
It is, Your Honor. Yes, sir.
All right, Mr. Fifelsky, do you want to establish the factual basis?
Absolutely, Your Honor. Mr. Federer, on or about April 4th, 2025, were you operating an ATV four-wheeler in the city of Adrian on Main Street going to a Speedway gas station?
Well, I was just in a parking lot is all. I wasn't driving on the roads, but yes,
Did you
I was driving.
Okay,
Yeah.
did you operate that four-wheeler ATV in a public parking lot?
Yes, sir. Yes, James.
And prior to operating that ATV, had you consumed alcohol?
Yes, I did, James.
And did you ultimately take an breathalyzer test with the police?
I did, Mr. Fifelsky.
And the results of that were 0.177 and 0.183. Do you have any reason to dispute those results?
I have none, Mr. Fifelsky.
And do you admit that you were operating while intoxicated on that particular date?
I do.
And lastly, do you also admit that you were previously convicted of 2 or more drunk driving offenses, one of which was March 28th, 2017 in the 22nd Circuit Court?
Yes. 8 years ago. Yes, Mr. Fifelsky. Yes.
And before that, were you also convicted of operating while intoxicated in the 22nd Circuit Court on or about June 23rd of 2015?
Yes.
Okay. I'm satisfied with that, Your Honor.
I'm satisfied as well, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D, Mr. Vano?
It has, Your Honor.
That's satisfied.
Mr. Fifelsky?
Yeah, defense is satisfied, Your Honor.
Okay. I will accept a plea. It has been given understandably, voluntarily, and accurately. Mr. Federer has had full knowledge of his rights and he has had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing February 19th at 8:15 a.m.
And Judge, I actually had a contempt of court on this in which Mr. Federer missed some blows at the end of November, beginning of December. He's since swapped out machines, so I'm willing to take back that contempt of court. He's doing much better. He's not missing any, and he's blowing triple zeros.
So what is the term is?
Based on that request, then I will dismiss the pending contempt
Thank you.
in the file.
Thank you, Your Honor. Thank you, Mr. Cost.
Thank you, Mr. Galvin.
Okay, Mr. Federer, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
100%, Your Honor. Yes, sir.
All right, and I'm going to put you in a breakout session with Mr. Moore from the probation department so he can collect your contact information and give you some instructions on what happens next.
Yes, sir.
Mr. Fifelsky, do you want to be a part of that breakout session?
No, Your Honor. No need. Thank you.
Okay. Mr. Federer, you can go ahead and log out or leave the meeting once you're done with the breakout session.
Yes, sir. Thank you, Your Honor.
Thank you, sir.
Thank you very much, Your Honor.
There is a gentleman that's logged in on a device labeled Samsung SMS156V. Can you tell me your name?
Eric Cooper.
Okay. Ms. White or Ms. Fry, Mr. Fry, you need to speak to Mr. Cooper before we start.
No, Your Honor.
I don't need to, Your Honor. Okay. And we have called these cases together with Megan Cooper's case. Do we want to do that again today?
Yes.
Okay, if you want to come forward, we're ready to call those. We are on the record in file -22084-FH 5-22161-FH People versus Eric Lee Cooper. Also file 25-22162-FH People of State of Michigan versus Megan Marie Cooper. We are here today for pretrial conferences in those cases, and we are proceeding today by partially by video conference and partially in person. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the prosecutor's office.
Lena Colbert White appearing on behalf of Mr. Cooper.
Brian Fry appearing for Eric Cooper on the newest case.
Ashley Hanson-Grimes on behalf of Megan Cooper, who is seated to my right in the courtroom today, Your Honor.
Okay, so where do we stand with these cases today? I guess let me start with Ms. White.
Your Honor, I have met extensively with the prosecutor's office, even in person, regarding pretrial settlement. The people have presented several offers to Mr. Cooper, and I have presented those offers to Mr. Cooper. And Judge, if I may just make a record, and I'm sure the prosecutor would be willing to put this on the record, the offer that was made to Mr. Cooper, it's my understanding that Mr. Cooper does not wish to accept any offers that are made by the prosecutor's office. And Judge, I just want to put that on the record so that all parties are comfortable and clear with what the offers are and with what my client's position is.
Okay, Ms. Arnold, is there an offer that's currently on the table for Mr. Cooper?
Judge, we did put it on the record last time. It's pretty complicated, but the bottom line is it involved 15-year prison sentence. And my understanding is Mr. Cooper is rejecting that. He rejected it last time on the record. There's been no meaningful counteroffer by the defense. So I guess we're ready to set the matter for trial.
All right, Mr. Fry, is there anything to address on the 25-22161 file?
Not at this time, Your Honor. Since the other case that Ms. White is handling would go first, we'd ask that mine be set for a pretrial. If mine gets set for a trial, it would have to be set for a trial with a different jury panel.
All right, and Ms. Hanson-Grimes, is there anything you need to address with your case with Ms. Cooper?
At this time, there's been no real meaningful offers made to Ms. Cooper that are not dependent upon Mr. Cooper. So at this time, the court had said that we were probably looking at next fall for a trial. The prosecutor has mentioned that they plan to file motions to consolidate. They haven't filed them as of this date. I don't know if the court wishes to avail us of maybe one pretrial on that February 11th date where you're scheduling now to have those motions be filed if they intend to consolidate. So we're not setting different dates at different times, or if I want to offer opposition, that I could do so on behalf of my client. So I guess I would defer to the court as to how you wish to proceed. I'm happy to have another pretrial on February 11th. I know that that's the date you're scheduling for right now if you're not full up. And then we can set those dates from there, and we would have a better, clear understanding of if Mr. Fry is also going to be consolidated into that, even though there are different dates and occurrences, as is Ms. Cooper, or if we're setting 3 different trials with 3 different juries.
All right, Ms. Arnold, do you have an intention with respect to consolidation at this point?
We may do a motion to consolidate. I think Mr.
Sorry to interrupt, but to consolidate which files? All three or the 225 cases or what exactly?
Perhaps all three. I'm not, I haven't really thought about consolidating Megan Cooper's, but I think that might make sense if the defenses are not inconsistent.
Well, obviously these cases, at least the 24 case is very old. The 25 cases are old as well, bound over last February. So I'm not really inclined to set another pretrial while people work that out. I will set a trial date in the 24 case. How much time do you think, Ms. Arnold, that you need for that trial?
Maybe 4 or 5 days.
All right, Ms. White, do you agree that that case would take approximately 4 to 5 days to try?
Yes, Your Honor, I agree.
All right, Francis, can you give us a 5-day jury trial date, please?
Yes. Tuesday, September 22nd at 9. Wednesday, September 23rd at 10:30. Thursday, September 24th at 9. Friday, September 25th at 9. And then Tuesday, September 29th at 9.
Tuesday, September 29th at 9 works for the defense.
Yeah, that's fine with us, Judge. And then I'd ask if Mr. Fry and Ms. Hanson Grimes are available in the event of consolidation. When I said that time frame, I think the consolidating the cases is not going to take substantially more time. I think that would be enough if we do consolidate.
Your Honor, I would certainly, if there is a formal motion for consolidation that is to be filed, I would expect time to respond to that and then have the court decide. As of right now, September, I would prefer to go into October or November. Also, 4 or 5 days, if my client's case were to be consolidated into the other case, would not be a sufficient amount of time. If we're essentially, if we're offering 3 separate defenses, or if we would need at least 2 weeks. So if that is the prosecutor's intent, 4 or 5 days is not going to cover it. And I think that Mr. Fry would agree with me on that.
I would agree, Your Honor. I mean, I haven't seen a motion to consolidate. I mean, but these are completely separate, unrelated incidences. I'm not sure what would be in that motion to consolidate. But if this was all tried together, we're essentially doing 2 separate cases together, or 3 separate cases together. It's going to take a lot longer than a week.
And we would also be requesting a separate jury panel as well. So 3 separate jury panels.
All right, so I'm going to set the 24 file for September 22nd, 23rd, 24th, 25th, and 29th, with a final pretrial on September 16th.
Your Honor, can you just confer? I think that Ms. White thought you were beginning on September 29th.
Yes, that's my understanding.
No, Ms. White, the trial dates were September 22nd, 23rd, 24th, 25th, and 29th.
Understood.
So are you available on those dates?
Yes, Your Honor, I am.
All right, and we'll use September 16th at 8:15 as a final pretrial. I will set the other two cases, the 25 case for Mr. Cooper and the case for Ms. Cooper for pretrials on that same September 16th date at 8:15 a.m. If and when there is a motion to consolidate anything, I'll deal with those when it's filed. Is there anything else that we need to address today?
So there will be no.
Should we set a, rather than waiting for a pretrial on Megan Cooper's case all the way until September 16th, can we set a quicker pretrial for her? Because in the event I don't consolidate, I think we should go ahead and pick trial dates for her. I mean, I think the trial dates would still be probably after Mr. Cooper's trial dates, but I just don't want to wait till September 16th to pick her trial dates and then have to go out another 6 months from then.
Your Honor, I kind of want to force the prosecutor's hand at this point. I again offer to come back on by February 11th, and any motions to consolidate need to be filed by that time.
That's maybe we set a pretrial just in Miss Cooper's case for the 11th and see if we're going to consolidate or not. That way we could pick trial dates on that date if we're not going to.
All right, so I'll set a pretrial conference for February 11th. In all three cases, and if there is going to be any motion to consolidate, that will be the deadline for such a motion.
Okay. Thanks, Judge.
And Judge, may I ask a question? So the February 11th date does not relate to Mr. Cooper on the case that I'm representing him on. I'm so confused. The people, if I understand correctly, are anticipating consolidating Megan Cooper's case with the case that my co-counsel on the other case is representing him on. Am I correct?
Well, there's also been some suggestion that she may ask to consolidate all three cases.
Mr. Fry's case with my case where I'm representing him on the death case with Megan Cooper's case. I'm just a little confused, Judge.
Yeah, I mean,
it's she has suggested she may try to consolidate all three cases. Your case, Mr. Fry's case, and Ms. Cooper's case.
Okay, what may I have the next date to reappear, Judge?
February 11th. At 8:15.
And if I understand correctly, if the prosecutor makes that decision to consolidate three cases, would we be there trying this case for about a month, Judge?
I don't have any idea at this point.
Thank you.
Is there anything else that we need to address with the case today?
Nothing.
No, thank you, Your Honor.
Thank you.
All right. Court will send out a scheduling order that has all of the dates we've discussed in.
I appreciate that, Your Honor. Thank you.
I can leave, Your Honor.
Yes, Mr. Cooper, you can log out.
Thank you. You have a great day.
Thank you, you too. Call jail for Mr. Tim. Mr. Amadeo, I do have Ms. Madison logged in. Do you need to speak to her?
I do not, Your Honor. Thank you.
And Mr. Murphy, I do have Mr. Spike here in the courtroom. Do you need to speak to him?
If I could please, Your Honor, if you could go and use the tablet in the hallway.
Mr. Spike, if you'll step outside to the hallway, there's an iPad just to your left as you go out the door. Okay, we can do Felicia. Ms. Madison, or if you're there, I need you to unmute your device.
I'm here. And Your Honor, before we start, I believe Mr. Goldstein's in your waiting room, and I think he wanted to make a record because he may be taking over the file.
Okay, he is logged into the Zoom session now.
Okay, thank you, Judge.
All right, so this is file 25-22455-FH, People versus Felicia Racine Madison. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Ms. Madison. We consent to the Zoom. Thank you for allowing the Zoom. Felicia, please state your name for the court.
Felicia Madison.
Okay, and so where do we stand with the case today?
Your Honor, we ran the prelim. Well, we ran it and waived it. We took testimony one day and then waived up after one witness testified that was a potential flight risk. At that point, we waived. I was just going to set this for trial, get the prelim transcript. It is my understanding Ms. Madison wants to hire Mr. Goldstein. If that is the case and he takes over, I guess he would ask for an adjournment, and I'll certainly provide all the discovery and have my staff get ready. I don't know if that formally has happened, Judge, but I was told this week Mr. Goldstein may be taking over the file. He could speak more intelligently on that, Your Honor.
Ms. Madison has contacted me, Your Honor. We're in the process of firming up the situation. I spoke to Mr. Amadeo prior to today, and we both, I think, sort of agreed this matter is ultimately most likely going to go to trial. And my suspicion is you're setting trial dates fairly far in the future, which would give me plenty of time to get prepared. But I think, Mr. Amadeo, you said the transcript is not ready yet. Is that right?
I didn't get it yet, and Prosecutor Sneed, I don't know if you have it. I did request it, but I didn't get it yet. I don't know if it's prepared as of yet.
Okay. Mr. Sneed, anything you wanted to add regarding the situation?
No, thank you, Your Honor.
I would just note the court's file does not have a copy of the transcript in it yet. I think based on what I've heard, let's adjourn the pretrial to January 28th at 8:15. And that way, I think things will be a little more solidified and we'll know exactly what's the status is and be able to set it for a trial at that time.
That's fine, Your Honor. Thank you.
Thank you, Judge. And should I just prepare a stip in order, Your Honor?
Yes, Mr. Amadeo, if you would prepare that stipulation order, I would greatly appreciate it.
No problem. Isaac, may I sign your name to it?
Yes, please.
Okay, thank you. Thanks, Your Honor. Have a good day.
Okay, thank you. So Ms. Madison, you can log out. Your next date is the 28th of January. You'll use all the same Zoom information that you used today.
Okay, thank you.
Your Honor, I also have the Michael Williams matter. I do not anticipate Mr. Williams appearing. He bench warranted in district court about a week and a half ago. And I have not
Okay,
been able to, I've not been able to reach him since that time, so.
I think we might have already issued one on violation that anyway. Okay. This is file 22465-FH, People of the State of Michigan versus Michael Scott Williams. We are here today for a pretrial conference in this case and proceeding today by video conference. The courtroom is also open to the public. First, I have the attorney's place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
David I. Goldstein appearing on behalf of the defendant.
All right, and the record should reflect this was set for a pretrial conference this morning at 8:15 a.m. It is now 9:03 a.m. Mr. Williams is not present here in the courtroom, nor is he logged into the Zoom session. I would also note that the court back on December 5th, 2025 issued a bench warrant related to some allegations about failure to complete his drug tests as required by the conditions of this bond. He's not present here today, so I am going to issue a bench warrant for his arrest for the failure to appear, and they'll set bond on that bench warrant in the amount of $10,000 cash or surety.
Thank you, Your Honor.
Thank you, Mr. Gold. Okay, the gentleman in the Zoom booth at the jail, can you tell me your name?
Terrence Tyndall.
Okay, Ms. Dumont, do you need to speak to Mr. Tyndall?
No, Your Honor, we're ready.
All right, this is file 25-22149-FH, People versus Terrence Jerome Tyndall. I'm sorry, so two files, 25-22149-FH and 25-22234-FH. Those are set for pretrials this morning. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Katerina Dumont for Mr. Tyndall.
All right, and Ms. Dumont, where do we stand with Mr. Tyndall's cases today?
Your Honor, I provided the court and prosecution with a signed plea agreement and advice of rights. I did speak with Mr. Sneed and asked for a no contest plea. I don't believe he had any objection to that based on intoxication and lack of recollection. The agreement is that Mr. Tyndall would plead no contest in file number 2522234F8 to count 1, possession of methamphetamine, and count 2, bringing contraband into the jail, with a recommended sentence of no immediate jail. And then his other file 2522149FH would be dismissed, along with if there are any habitual offender supplements.
All right, is that a complete and accurate statement of the plea agreement, Mr. Sneed?
Yes, it is, Your Honor.
Mr. Tyndall, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
You are Terrence Jerome Tyndall?
Yes, sir.
Mr. Tyndall, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 25-22234-FH to count 1, possession of methamphetamine?
Yes, sir.
Your Honor, it would be no contest.
No
I apologize. Yeah. Is it your intention to plead no contest to that charge?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine?
Yes, sir.
Is it also your intention to plead no contest today to count 2, bringing contraband into the jail?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $1,000 fine?
Yes, sir.
Are you satisfied with Ms. Dumont and the advice that she's given you?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Ms. Dumont?
Yes, Your Honor.
Is that also your understanding, Mr. Tindall?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Tindall, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving them up?
Yes, sir.
How do you wish to plead to the charge that on or about January 17, 2025 in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of possession of methamphetamine or ecstasy?
No. Good. What up, please? No contest?
No contest. Yeah.
No
The
contest?
no contest.
And how do you plead to the charge that on or about the same date in the city of Adrian, County of Lenawee, State of Michigan, you did commit the offense of bringing contraband into the jail?
No contest.
Has anyone made any threats or promises to you to induce you to plead no contests to those charges?
No, sir.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that those pleas are given as a result of threats or promises that are that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Tindall to plead no contest today?
No, Your Honor.
No, Your Honor.
Mr. Tindall, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record today?
No, sir.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead no contest today?
Yes, sir.
All right, and Ms. Dumont, how are we establishing the factual basis for the no contest?
I can place it on record with the Michigan State Police report.
All right, go ahead.
So I have a Michigan Department of State Police report, incident number 014-0000231-25. The date is January 17th of 2025. The Trooper Gillig, he indicated that he was on patrol, sitting stationary in front of 7-Eleven gas station on 304 East Beecher Street in Adrian, Michigan. He observed Mr. Tindall exit the state gas station, and that he revealed he had a criminal bench warrant out of the 2A District Court. He initiated a traffic stop. At that point, he took him handcuffs, advised him he had a warrant for his arrest. He complied. He was transported to the Lenawee County Jail. Prior to arriving inside the Lenawee County Jail, the trooper asked Tyndall if he had anything illegal on his person that the jail staff would find. He advised no. He advised if there was on his person a smuggling charge. When he got to the jail and CO Westgate conducted a search of his person, he located Sorry. Okay, can you hear me okay
Yeah,
now?
we lost you for a second. Yeah, we can hear you now.
He located a clear baggie of suspected narcotics on Mr. Tyndall's person. It was seized, placed in a property, and then tested. It turned out to be 2.3 grams of methamphetamine in a clear plastic baggie. And I think that should be sufficient.
Mr. Sneed, are people satisfied with that as a factual basis?
Yes, I am. Thank you.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, thank you.
Ms. Dumont?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Tyndall has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed it on the record here today. I will refer this matter to the probation department for a pre-sentence investigation interview. Mr. Tyndall, when you do that interview, please be truthful about this offense and about your background.
Yes, sir.
I will set sentencing for my next available date is February 19th at 8:15 a.m.
Thank you.
All right, Mr. Tyndall, you can let the officer with you know that you're done with court for today.
Right.
All right, Ms. Underwood, are you ready to proceed with Mr. Dickerson? Oh, I'm sorry, looks like we've lost Ms.
Pardon me, Your Honor.
I don't know, but I did the referral. Maybe.
Yeah, we don't have Ms. Underwood. I think she's logged out. So
She logged out. She's with Judge Anzalone right now. We have a hearing in front of Judge Anzalone, and we're gonna just do a quick adjournment.
Okay.
Then I think Miss Underwood's gonna come back to your court, and I'm still here in your court as well.
Okay.
Thank you, Your Honor.
All right, Mr. Dagger Margosian, are you ready to proceed with Mr. Turns?
Yes, sir.
This is file 25-22481-FH, People of the State of Michigan versus Darrell Quincy Turns. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, can you have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Your Honor, good morning. Michael Dagger Margosian for Mr. Turnez.
And where do we stand with Mr. Turnan's case today?
Your Honor, I've been speaking with Ms. Arnold. I think there are still a few conversations that have to be had to see if we can resolve this case. So I'd be asking for a very short adjournment, maybe 1 to 2 weeks.
Okay, Ms. Arnold, is there anything we need to address from the people's side?
No, thank you.
Okay, I can adjourn it to January 28th at 8:15 a.m.
That works. Thank you, Your Honor.
Judge, does it? Does the court have availability on the 21st? Only because I have a pretrial and a death case in Anzalone's on the 28th.
I've got 20 pretrials already set for that morning, so I can't.
Okay. All right, that's fine. Thank you.
All right, so January 28th at 8:15. Mr. Turnus, you can let the officer with you know that you're done with court for today. Okay, Mr. Murphy, are you ready to proceed with Mr. Spike?
Yes, Your Honor.
Mr. Spike, can you come forward to the podium, please?
Dan, do you mind covering some shit for me today?
It's Judge Olsavers courtroom. Can we get West? Wait. Thank you.
This is file 25-22288-FH People versus Benjamin Paul Spike. We are here today for a pretrial conference, a final pretrial conference, as well as a contempt of court for alleged failure to appear. We are proceeding today partially in person, partially by Zoom. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bannon.
Alex Bayonetto for the people.
Matt Murphy appearing on behalf of Mr. Spike.
And sir, you are Benjamin Paul Spike?
I am.
Mr. Murphy, where do we stand with Mr. Spike's case today?
Your Honor, there's an offer from the people for Mr. Spike to enter a no contest plea to domestic violence under 769-4A, the deferral statute. The felony in this matter will be dismissed. Mr. Spike wishes to again enter that or accept that offer and enter a no contest plea to the domestic violence based upon lack of memory. I believe that my office is sending over the police report for the court to use to satisfy the factual basis in the matter if there's no objection by the prosecutor.
No objection, Your Honor, or I can put the factual basis on the record. I do have the report pulled up.
Whichever the court prefer. I mean, I would have no concern as long as it's just from the police report, so it doesn't matter. And Your Honor, in regards to the contempt of court, we're asked that just a not guilty plea be continued and that be set for a another pretrial or hearing on the date of sentencing.
All right. Okay, Mr. Spike Bay is going to hand to you an advice of rights form. Need you to take whatever time you need to read through that, and if you're comfortable with it, sign it, please. record certified, I do have a signed advice of rights form from Mr. Spike, and I have placed that in the file. So, Mr. Spike, you raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
You are Benjamin Paul Spike, correct?
Correct.
Mr. Spike, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to domestic violence?
No. No contest. I'm sorry, Your Honor.
I'm sorry, yep. Is it your intention to plead no contest to domestic violence?
Correct. Yes.
I'm sorry, so we needed amended information on this because the count 2 was aggravated.
I apologize, Your Honor. I will get that to the court now. I missed that.
Okay. So Mr. Spike, I'm gonna have to have you take a seat, and as soon as we get the amended information, we'll proceed.
Thank you, Your Honor.
Okay, Mr. Malero, are you ready to proceed with Mr. Garreau?
Yes, Judge. Yeah, I am.
Richard Garreau. This is file 22-20936-FH, 25-22330-FH, and 25-22331-FH. People versus Richard James Garreau. We are here today for pretrial conferences in the 25 cases and an alleged probation violation in the 22 case. We are proceeding today by video conference. First, may I have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Richard Garreau. This is actually John Glazer's case. I'm handling the matter for him today.
And Mr. Malero, where do we stand with Mr. Garreau's cases today?
Your Honor, it's my understanding Mr. Garreau is under a sentence that ends on the 27th of this month. So I'd ask to adjourn this matter out perhaps a week or two for Mr. Glazer to see if he can get this resolved before his release date.
All right, my first available date is January 28th, so I'll set it for January 28th at 8:15.
Thank you, Judge.
Mr. Malero, would you do a stipulation order for those adjournments, please?
Yes, I will.
All right, Mr. Garreau, you can let the officer with you know that you're done with court for today.
Yep, have a good day.
Okay, let's see, sir, you're Mr. West?
Yes, sir.
Mr. Murphy, do you need to speak to Mr. West in a breakout session?
If I could, please, Your Honor. I'm sorry.
And Mr. Malero, do you need to speak to Mr. Whiteman?
Yes, I do.
Pardon me, Your Honor.
Yeah.
Just to give you a quick update, Miss Underwood and I are done with our case in front of Judge Anzalone. So I think I've got two cases with you this morning. One is Enrique Castillo, and then the other one's Bianca Videlas.
Okay.
I just want to make sure those are on your docket still.
Yes.
All right, thank you, Your Honor.
What's your name?
Oh, Robert Allen.
You're from Mr. Murphy. Okay. Okay, Mr. Malero, are you ready to proceed with Mr. Whiteman?
Yes, Judge.
This is file 24-22035-FH and 25-22386-FH, People versus Alan Gene Whiteman. We are here today for a pretrial conference in both of those files. We are proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Alan Whiteman.
And Mr. Malero, where do we stand with Mr. Whiteman's cases today?
Your Honor, I'm asking to adjourn the matter for a couple of reasons. One, he was approved for Salvation Army Harbor Light, and he's on a wait list. The primary reason is that we were going to have him screened for recovery court, but there was a mix-up as to whoever needs to screen him, where they didn't realize he was in jail. And so we've resubmitted the request to have him screened. So that's the reason for our request, Your Honor.
Mr. Sneed, is there anything we need to address from the people's side?
No, I have no position, Your Honor. Thank you.
All right, so I'll adjourn this to February 4th at 8:15. Both files, I would anticipate setting 24 case for trial on that date. There is a resolution.
All right, thank you, Judge.
All right, Mr. Whiteman, you can let the officer with you know that you are done with court for today. All right, Ms. Underwood, are you ready to proceed with Mr. Dickerson?
Yes, Your Honor.
Mr. Dickerson, can you start your video so I know you're there? Okay, this is file 25-22403-FH, People of State of Michigan versus Sean Davis Dickerson. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Hoffman?
Thank you. Good morning, Your Honor. Benita Hoffman, Assistant Attorney General on behalf of the people. My bar number is P48738.
Thank you, Your Honor. Rhonda Underwood for Mr. Hoffman this morning. Mr. Dickerson, I apologize.
All right, and where do we stand with Mr. Dickerson's case today?
Your Honor, I'm afraid with both the forbearance of the court and the prosecutor, with the holidays and certain circumstances, Mr. Dickerson and I need to have a conversation. So I'm asking for one adjournment, Your Honor, and we should be able to resolve this matter.
Ms. Hoffman, is there anything that you need to address?
Well, Your Honor, we've been back a couple of different times on this. Normally, I would ask the court to set it for trial, but given that it was the holidays, that the holidays have passed, I'm just wondering if it wouldn't be better for Ms. Underwood and Ms. Dickerson to go into a breakout room and have a conversation while we wait to see if this is going to resolve today.
I think they've already had an extended conversation in a breakout room this morning. This case is, it was found over 107 days ago. So this case is aging and needs to resolve. And if it doesn't resolve, I mean, that's fine too, but then we need to set it for a trial. We need to move forward in one way or another. So this will be the last adjournment. I will set this for February 4th. If it's not, if there's no resolution on February 4th, I will set it for a trial on that date.
Thank you, Your Honor.
Yo. Hello.
All right.
So warrant
Yeah,
for
we can hear you,
exhibits.
Mr. Moore.
Yeah, is he there? And
All right, so Mr. Dickerson, your next date is February 4th at 8:15 a.m. You'll log in using all the same Zoom information.
Thank you.
Thank you.
Mr. Malero, do you need to speak to Ms. Juilliard Eichenberg?
No, Judge, we have a plea to put on. I think we sent the plea agreement to the court and there's been an amended information filed. Did you hear me?
All right.
Did you hear
Yeah.
anything?
Yeah, I did. Ms. Underwood, do you need to speak to Ms. McClenny Vidales? I wasn't able to hear what you said.
Yes, I'm here.
I can't hear you, Ms. Underwood.
Can you hear me?
Now I can. Do you need to speak to Ms. McClenny Vidales or Ms. Brooks? I'm sorry. I'm not hearing.
Can you hear me?
I can hear you now. Do you need to speak to Ms. Brooks?
I don't.
Clark.
Oh, okay. No, I believe we have a plea in this matter, Your Honor.
Do we have an advice of rights form? I don't have anything in the file.
Ms. Becca Badale has signed one in Kentucky, Your Honor, and emailed it back, a signed copy. Would that be sufficient to the court?
If you can send it to me, yeah.
Thank you. We will send that right over. I thought it had been sent.
We'll proceed with her case when I get that then.
Okay. Thank you.
Mr. Murphy, are you ready to proceed with Mr. West?
Yes, Your Honor.
This is file 20-20069-FH and 25-22294-FH, People versus Wendell Charles West. The 25 case is set for a pretrial, as well as a hearing on alleged violation of bond conditions. The 20 case is set for final pretrial, as well as alleged contempt on violating bond conditions. First, I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Matthew Murphy, appearing by Mr. West.
All right, so this is a listed as a final pretrial. I don't think it actually is. I don't see a scheduling order. Where do we stand with these cases today, Mr. Murphy?
Your Honor, we did have a trial scheduled, I thought, and then it was vacated. I think maybe Mr. West missed a court date. And in regards to the matter, I guess, well, at this point, one of my thoughts was I was going to ask the court. I wanted to ask for another pretrial and see if the court would be willing to allow Mr. West to be released to an inpatient rehab facility. I believe Mr. Sneed would object to that at this point. But I believe that it would be beneficial. I don't know if it would ultimately would result in a different plea from the people, but I believe that it would be beneficial for Mr. West. At this point, the offer from the people, I believe, is for him to plead to both counts with no habitual offender status on it, so 2 OWIs, 1 in each file. And the people would make a recommendation for 6 months in jail. I guess, you know, in regards to that, Mr. West was concerned about a recommendation. That's why, again, I wanted to adjourn and see if we could get the rehab worked out, and if there would be some sort of, you know, more concrete offer from the people in regards to the length of jail sentence, or if there would be a change in their recommendation, or possibly a Cobb's conference with the court to see if there would be any thoughts from the court in regards to a sentence with Mr. West. Again, he expressed on his own, it's not something I brought up to him at all in the case until now. And I think that's significant given that Mr. West's history is pretty much drinking related. There's no question that he understands the severity of that issue. But other incidents, other cases I have, rehab's brought up in a different manner than this. So I would ask the court, again, I believe this should be at the objection of the people. But I think right now what the defense is asking for is if we could adjourn for whatever would fit the court's schedule best, and I would have him screened for an inpatient rehab if the court would allow him to be released to that inpatient rehab. If not, if the court's not inclined to do that, I would have to ask for another breakout if the court's requiring a plea today or a continuation to trial. Again, I think that we can resolve this. It's just a matter of you know, whether or not that rehab is something that's going to be a factor in it or not. So that's what the defense is asking for. I'm sorry, that was a bit long-winded, Your Honor.
All right, Mr. Sneed.
Your Honor, I have no objection to an adjournment for another pretrial to continue negotiations. I would defer to the court regarding any release conditions based upon the fact the case is 7 months old. The other case is 5 years old, and we still don't have resolution for 2 OWI cases. So with that, I have nothing further.
All right, I am not comfortable granting a release to Mr. West. He, in the 2020 case, he failed to appear in January of 2021 and was not seen again until 2025. When he had picked up the charges in the 25 case for another drinking and driving. So I, at some point, have to act to secure the public, and I'm frankly scared that if released, Mr. West would kill somebody. So I'm not willing to modify the conditions of his release at this point. So I don't know if that changes what you want to do today, Mr. Murphy. I'm willing to set it for another pretrial, or we can set it for trial.
Could we do another pretrial, Your Honor? I think I may end up. The reality, I think, is we're going to get this figured out, and I may contact the court before the next pretrial and try to schedule an off busy day to have the thing handled. I think it'll probably be resolved pretty quickly now that that's been answered. So if you would please, just another pretrial.
I can set it for February 4th at 8:15 a.m.
Thank you, Your Honor.
All right, Mr. West. Oh, you know what? We don't have prints in the 25 file that I could find, so I'm going to sign an order for prints in the 25 file. They should be able to take care of that at the jail.
Your Honor, my office will do the stipulation order on both files for that February 4th date.
All right, thank you. Mr. West, you can let the officer with you know that you're done with court for today.
Thank you, sir.
Mr. West, I'll be able to talk to you again soon, okay?
Thank you, sir.
Thank you.
Have a good day.
Thanks, you too.
Is Attorney Muad still in the court?
I don't know. He was here and then he was gone and then he was here again and I think he's gone again.
Okay, he's the attorney on the Castillo case. Okay.
Mr. Murphy, Mr. Allen is here in the courtroom. Are you going to need to speak to him?
If I could, Your Honor, we have a plea agreement. I just wanted to make sure he was understanding everything.
All right, Mr. Allen, if you'll step outside, there's an iPad right outside the door to your left.
Yes. Yeah. Mr. Fry, have you heard from Mr. Edwards? Okay. Come forward. Get that taken care of.
This file 25-22177-FH, People of State of Michigan versus Edward Earl Edwards. We are here today for a pretrial conference in this case, and we're proceeding today by video conference, partially in person, partially by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Brian Fry, appearing for Edward Edwards.
And records reflect this was set for a final pretrial actually this morning at 8:15 a.m. It is now 9:49 a.m. Mr. Edwards is not present here in the courtroom. He is also not logged into the Zoom session. Mr. Fry, is there anything you'd like to say with respect to Mr. Edwards at this point?
Your Honor, I haven't had any contact with Mr. Edwards since October. I'm not sure where he is. I think there's already a bench warrant issued for a violation of bond conditions. But I haven't had any contact with him, so I'm not sure where he is.
Judge, that is correct. He was supposed to be drug testing with me, wasn't doing it. And it looks like back in November, a bench warrant was issued for his arrest.
All right, I am going to then vacate the trial dates of the 13th and 14th of this month. And I will issue a bench warrant for Mr. Edwards for the failure to appear. I will set bond on that bench warrant in the amount of $50,000 cash or share.
Thank you, Your Honor.
Thank you. All right, I have the advice of rights form now for Ms. Clark, so we can go back to them. Beyond the hours.
Hello. Can you hear me?
Yeah, we can hear you.
Thank goodness.
All right, we are back on the record in file 25-22160-FH, People of the State of Michigan versus Bianca McClenny Vidales. We are here today for a pretrial conference in the case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Burke.
Your Honor, thank you very much. Good morning. My name is Mark Burke. My P number is 54935. I'm with the Attorney General's Office appearing for the people.
Ron Underwood for Ms. McElhenney Vidales, Your Honor.
All right, and where do we stand with Ms. McClenny Vidales' case today?
I believe we're prepared to enter a plea this morning, Your Honor. If the Attorney General's Office could put the plea on the record, the offer on the record.
It's my pleasure. Your Honor, the defendant's charged with 3 counts of child support found to pay. It's my understanding the defendant's going to be pleading guilty to count 1, and the people would be dismissing counts 2 and 3 without prejudice. And the people would be recommending a delayed sentence for a period of about 11 months. During the delay, the defendant's to pay a minimum of $250 per month. And if she's able to reduce the arrearage to $10,000 or less during the delayed sentence period, then count 1 would be reduced at the end of the delayed sentence to an attempt failure to pay child support, which is a 2-year high court misdemeanor. If the defendant's able to pay the arrearage off in full during the delayed sentence period, then essentially count 1 would be dismissed, and then the defendant would be sentenced and added count 4 of disorderly person, which I believe is a 90-day or 93-day misdemeanor. Currently, the arrearage, Your Honor, is $14,968.30. That's as of, I believe that's as of 2 days ago. In addition, the defendant does not have a current support obligation, which is great, which means there's nothing that's growing. So, but she has to make a minimum of $250 a month during the delayed sentence period, with the understanding that if she can reduce to $10,000, she gets the attempt. Paid in full, she gets the disorderly. Thank you, Your Honor.
All right, and Ms. Underwood, is that a complete and accurate statement of the agreement?
That is a complete and accurate understatement, Your Honor.
All right, Ms. Clark, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Bianca Clark, is that correct?
That is correct.
And you were formerly known as Bianca McClenny Vidales, is that correct?
That is correct.
Ms. Clark, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, failing to pay child support?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine?
Yes, Your Honor.
Are you satisfied with Ms. Underwood and the advice that she's given?
Yes.
Either the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. Burke?
That's correct, Your Honor. Thank you.
That's
Ms.
correct,
Underwood.
Your Honor.
Is that also your understanding, Ms. Clark?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Clark, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, I understand.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, I understand.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, sir.
Do you understand that you're giving those rights up?
Yes, I understand.
How do you wish to plead to the charge that on or about July 1st, 2018 through February 29th, 2020, in the city of Adrian, County of Illinois, State of Michigan, that you did commit the offense of failing to pay child support?
I choose to plead guilty.
Has anybody made any threats or promises to you to induce you to plead guilty?
No.
Do you understand that if I accept the plea, you're giving up any and all claims that that plea was given as a result of threats or promises that weren't disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, I understand.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Clark to plead guilty?
None from the people, Judge. Thank you.
No, Your Honor.
Ms. Clark, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record today?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, I understand.
Is it your own choice to plead guilty today?
Yes, it is.
Ms. Underwood, do you want to establish the factual basis?
Thank you, Your Honor. Ms. Clark, let me take you back to July 1st, 2018 through February 29th, 2020. Did you have a child support obligation in the Lenawee County Circuit Court in Adrian, Michigan, in the county of Lenawee, in the state of Michigan, in case number 200803 253 2534 DM. And did you fail to pay child support on that file?
Yes, ma'am, I did fail to pay directly to the courts.
Okay. Thank you. And you know you're supposed to pay every child support payment.
That is correct.
Okay. And you didn't do that?
No, ma'am.
Okay. I believe the factual basis has been established, Your Honor.
Mr. Burke, are the people satisfied with the factual basis?
The people are satisfied, Judge. Yes, thank you.
Has the court complied with MCR 6.302 B, C, and D, Mr. Burke?
The people are satisfied, Judge. Yes, thank you.
Ms.
It
Underwood?
has, Your Honor.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Clark has had full knowledge of her rights. She's had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for February 20th at 8:15 a.m.
Your Honor, I believe this is a delay.
Oh, I'm sorry.
So the February 20th date would be when the defendant's placed on delay sentence. Is that right, Your Honor?
Yeah, so we'd just be putting her on the delayed sentence with the supervision terms at that time.
Very good. Thank you so much, Your Honor.
All right, Your Honor. Thank you. And I will thank you.
Thank you, Ms. Underwood.
Thank you,
All
Mr.
right, Ms. Clark, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background. I am going to put you in a breakout session with Mr. Moore from the probation department so he can collect your contact information and give you some instructions on what happens next.
Okay.
And okay, Mr. Mawad, are you ready to proceed with Mr. Castillo?
I am, Judge. Thank you very much.
And you're getting off your boss, right?
Yeah.
Oh, you can go.
All right, this is file 25-22269-FH, People of State of Michigan versus Enrique Manuel Castillo. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Burke.
Thank you. Good morning again. For the record, my name is Mark Burke. My P number is 54935. I'm with the Attorney General's Office appearing for the people.
Your Honor, good morning. Elias Muad appearing on behalf of Mr. Castillo, and good morning to Mark. How you doing, Mark?
I'm well. Thank you. Good to see you.
Good. Good.
All right, and sir, you are Enrique Manuel Castillo?
Yes, I am.
All right, Mr. Muad, where do we stand with Mr. Castillo's case today?
I'm sorry. I can hear you now, Judge. What I'm going to do is just zoom out so I can have, or not zoom out, but okay, I'm going to keep the video off. Judge, my understanding is Mr. Castillo has made some payments. Can I ask the Assistant Attorney General where you're at right now?
Yes, based on my review of the file and the information, the defendant has made substantial payments over the last 12 months. He's paid about $19,000 or so in the last 12 months or so. The defendant's arrearage right now is $11,043.04. That's as of January 5th. He has an ongoing support obligation of $851 a month. Based on the discussions, I believe the defendant's going to be pleading guilty to one count of attempt child support failing to pay, which is with a recommendation of the people for a delayed sentence for a period of 11 months, if the defendant pays in full, and also pays the extradition cost of $2,482 during the delayed sentence period, then the people would I guess move to dismiss count one, and then defendant would be sentenced and added count two of disorderly person, which again is a 90 or 93-day misdemeanor. Obviously, naturally, the defendant would have to continue to pay his current support obligation as well, which again is $851 or whatever the court. If the court orders a different amount, he'd have to pay that amount every month as well. So that's what the people are offering.
Yeah, I appreciate that very much. So, Mr. Castillo, there's an offer for a plea, something that we discussed, that you'll have 11 months to pay everything off. Once you do, it goes down to a misdemeanor. Do you want to take advantage of that plea today and get your plea done, and we'll come back for a sentencing?
Yes.
Okay.
I would need an amended information for that plea, and I would also have to have a signed advice of rights form for Mr. Castillo, which I don't have, so I can't take his.
Okay. Can we do it next week, Judge, or in 2 weeks? What works good for the court?
I'm filled up with pre-trials for the next 3 weeks, so my next available date is February 4th.
We'll get it done. Now that I know that Mr. Burke is on the case, we can work that out. If that's fine, and he'll make more payments too, so that'll be good. If that's good with the court and good with the AG's office.
I'm okay with that, Your Honor. So that we can, I'll have the Lansing office file an amended information to include the attempt.
Okay, and again, I'll need that and a signed advice of rights form from Mr. Castillo.
I'll take care of that, Judge.
All right.
So February 4th at 8:15, Your Honor?
February
Correct.
3rd or 4th? 4th, okay. Okay.
All right, perfect. Your Honor, thank you so much. Appreciate it.
Thank you, everybody.
Mr. Mudd, thanks so much. Good to see you.
Yeah, good to see you. Bye-bye.
Thank you.
Mr. Castillo, you can go ahead and log out then.
Okay, thank you. Bye.
Okay, I've got the amended information for Mr. Spike. So Mr. Spike, you want to come back forward, please? All right, we are back on the record in file 25-22288-FH, People versus Benjamin Paul Spike. Here's we have Mr. Sneed now for the people. So Mr. Sneed, would you like to place your appearance on the record?
Yes. Isaac Sneed for the people.
All right. And Mr. Spike, I think my last question to you was whether it was your intention to plead guilty today to, it would be count 3 now on the amended information, domestic violence. I'm sorry, and it was no contest, right?
No contest.
So your intention to plead no contest to that charge?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 93 days in jail and or a fine of $500? Are you satisfied with Mr. Murphy in the advice that he's given?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed the possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. Sneed?
Yes, Your Honor.
Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Mr. Spike?
Yes, Your Honor.
If a guilty plea or if a no contest plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial, and explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Spike, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
I understand, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
I agree. Yeah.
Okay, do you understand that?
Yes.
Okay. If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No. Your Honor.
Do you understand that you're giving them up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about May 20, 2025, in the city of Adrian, County of Illinois, State of Michigan, that you did commit the offense of domestic violence?
No contest, Your Honor.
Has anybody made any threats or promises to you to induce you to plead no contest to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that that plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor defense counsel aware of any promises, threats, or inducements other than plea bargain to induce Mr. Spike to plead no contest today?
No, Your Honor.
No, Your Honor.
Mr. Spike, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record today?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court is not bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. You understand?
Yes, Your Honor.
Is it your own choice to plead no contest today?
Yes, Your Honor.
Mr. Sneed, do you have the police report for the factual basis?
I can bring one up, Judge.
Yeah, and I don't know if it helps. We had tried to send one to the court for use if the court wanted to. I don't know if that made it through or not.
I'm looking for it.
Sorry, Your Honor, I'm just reviewing the plea agreement. It says an added count 3 of attempted R&O. On my amended information, the added count 3 is for domestic violence.
Yeah, that's what it's supposed to be. It's to domestic violence under 769-4, and I believe that's what the court had said on the record too. If I'm not mistaken.
So is that not in compliance with the plea agreement then, Matt?
Yeah, it's not to an attempted R&O, it's to the domestic violence under 769. Isn't that what was on the amended information?
Yes. Okay. Sorry, I just. So
just to be clear, that was
domestic violence.
Yeah, it was, and I believe that was the court had said that as well on the record. That count 3 is domestic violence. The added count 3 of domestic violence under 769-4. Because at first it was just the count 2, which was aggravated domestic violence.
Okay, well, for purposes of the factual basis, then it's true on or about May 20th, 2025, in the city of Adrian, county of Lenawee, state of Michigan, that the defendant did assault or assault and batter Paul Spike, a resident or former resident of the defendant's household.
All right, so I have a police report from the City of Adrian Police Department, report number 250007662, dated May 20th, 2025. Written by Officer Callens, that indicates that on May 20, 2025, Benjamin Spike assaulted his father, Paul Spike. Allen was dispatched to a location regarding two males who were involved in a fight. Paul Spike had a laceration, bruising over his left eyebrow, a significant amount of blood on his face. Paul Spike advised that he was punched several times by Benjamin Spike. Another witness advised that Benjamin Spike was the aggressor in that altercation. Paul Spike is the father of Benjamin Spike. I believe that would satisfy the factual basis for the domestic violence charge. Do you agree with that, Mr. Sneed?
I do. Thank you, Your Honor.
Mr. Murphy, are you in agreement with stipulating that those facts would be established if there were a trial, and that those do satisfy the basis for a domestic violence charge?
Yes, Your Honor. The police report mentioned by Your Honor that you have in your possession, that is the police report we received in this matter. There were no, everything that the court repeated was stated in that police report, and we would stipulate and agree to that. And obviously, we believe that satisfies the factual basis. They were father and son. Obviously, that meets the requirement for the domestic relationship. Well, they are father and son. I'm sorry.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor.
Mr. Murphy?
It has, Your Honor. Thank you.
All right. I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Spike has had full knowledge of his rights to have competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for February 20th at 8:15 a.m. So this is a misdemeanor then. So Mr. Spike, you will need to report to Mike McCarron in the district court probation office this coming Tuesday at 8 a.m.
Yes, sir.
So that is Tuesday, January 13th at 8 a.m. downstairs on the first floor. Right, you are all set for today.
Thank you, Mr. Spike. I'll talk to you soon, okay?
And we'll set the contempt for the same sentencing date.
Your Honor, should my office do a stipulation order for that contempt to be set to that date?
No, I don't think that's necessary.
Okay, thank you.
All right, Mr. Allen. This is file 25-22467-FH and 25-22468-FH, People versus Robert D. Allen. We are here today for pretrial conferences in both of those cases. We're just going to have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Matthew Murphy appearing on behalf of Mr. Allen.
And Mr. Murphy, where do we stand with Mr. Allen's cases today?
Your Honor, I was having a discussion with Mr. Barnetto about this case, and the plea offer from the people would involve Mr. Allen pleading to possession of cocaine with an agreement for just probation if he was to complete rehab successfully. Mr. Allen did have his bond changed when he was in custody to allow him to be released to rehab. We have that process going. He is waiting for a bed to rehab, but obviously he's not in custody. He had bonded himself out, waiting for that bed. I misrepresented Mr. Barnetto. I believe I thought that Mr. Allen was already in rehab because he wasn't in the jail. I think at this point, what I was going to ask is, again, just to clarify to Mr. Sneed, to the people, that Mr. Allen is obviously not in a rehab. He's obviously here, though. I was going to ask the court to adjourn for another pretrial. Mr. Allen, again, is waiting on the bed. My understanding is it should happen here pretty soon. Get him into that rehab facility. Again, my understanding is Mr. Barnetto wanted him to perform successfully in that. That's part of the plea agreement. So that's why I was asking for that adjournment. Again, I don't believe there's going to be any issues with that. It's just a matter of it not having occurred yet. So if Mr. Sneed and the people wouldn't object, that's what we're asking for, is an adjournment.
No objection.
All right, what I will do is adjourn this then to February 18th at 8:15 a.m.
And Judge, Mr. Allen has been testing at the facility. He's tested 7 times thus far. He's done pretty well. He doesn't miss. He's either negative or he's only positive for THC. So Mr. Allen, if you do go into treatment, make sure you contact me because I'm going to have you sign necessary releases.
All right, I'm also, I don't have prints for the 25-22467 file. So I'm going to do an order for prints, and Mr. Allen, you're going to need to take that to the Adrian Police Department and get another set of prints done.
I can do that today.
If you want to wait to get your copy of the order for prints, you won't be able to do it today, but you can do it any Monday through Thursday at 7:30 a.m. at the City of Adrian Police Department. Okay. Right. All right, so you're all set for today. If you want to wait, just take a seat and we'll bring that paperwork out to you when we have it.
All right, thank you. All right, man.
Thank you, Mr. Allen. You have a good day, okay? Your Honor, that was all that I had scheduled in your court. I was going to go ahead and log out now if that was okay with you.
Okay, thank you, Mr. Murphy. Have a nice day.
Thanks, everyone. Have a good nice day. Thank you.
Okay, Mr. Helton. Ms. Underwood, you need to speak to Mr. Helton.
Yes, Your Honor. Thank you.
Okay, Mr. Helton, if you'll step outside the door, there's an iPad just to your left, right outside the door, and I'll set it up so you can speak to Ms. Underwood.
To jail?
Is he real or not real? We have Mr. Valero right now. Called the Megan Warwick case. We still have a brother in jail. Yeah. Yeah. This is file 24-21952-FH, People of the State of Michigan versus Megan Cheryl Orwig. We are here today for a hearing on a request and summons for probation violation. The record should reflect that this matter was set for hearing this morning at 8 a.m. Ms. Orwig was ordered to appear to respond to the summons probation violation. It is now 10:25 a.m. Ms. Orwig has not appeared. She's not present here in the courtroom. She's not logged into the Zoom session. She has not been here at any point this morning. I am going to issue a bench warrant for her arrest, and I will set bond on the bench warrant in the amount of $10,000 cash assured. No. You're doing Torres. This is file 23-21533-FH, People of the State of Michigan versus Julian Dominic Torres. We are here today for a hearing on a request and summons for probation violation. The record should reflect that the summons for probation violation directed Mr. Torres to appear in court here this morning at 8 a.m. It is now 10:26 a.m. Mr. Torres has not appeared either by being present in person or by logging into the Zoom session at any point this morning. I am going to issue a bench warrant for his failure to appear. I'll set bond on the bench warrant in the amount of $10,000 cash or surety. Okay, this is file 25-53141-PP, Richard Allen Wise versus John Willard Helton II. We are here today for a hearing on an alleged violation of a personal protection order. And we are proceeding today partially in person, partially by video conference. Ms. Underwood, do you want to place your appearance on the record? Not hearing you again, Ms. Underwood.
Can you hear me?
Now I can hear you.
Okay, Rhonda Underwood from Mr. Houghton this morning, Your Honor.
And so you're John Willard Helton II. Okay. All right, Ms. Underwood, where do we stand with Mr. Helton's case?
Your Honor, it's my understanding that there is a hearing date set on a motion to have this PPO dismissed, Your Honor. I believe, is that the 18th?
Yes.
Then we would humbly request that this be adjourned to that date, or in the alternative, Your Honor, I don't believe I see anyone there. We would being that there's no one here from the other side, we would ask for a dismissal of the violation at this point.
Well, I'm not going to do that. There was a hearing scheduled yesterday on Mr. Helton's motion to dismiss, and he did not appear timely, and so the court dismissed that and apparently motion. So Mr. Wise was here yesterday, and this wasn't set as an evidentiary hearing on the matter, so I'm not going.
Okay. Then if you could set the date at the motion, Your Honor.
Sorry.
If you could set this on the same date as the motion.
Well, I don't know. I mean, if he's alleged to have violated a valid personal protection order. If I terminate the motion at his request, it doesn't change the fact that he's alleged to have violated it when it was in place. So if he wants to have a hearing on the alleged violation, he can do that, but I don't see what
All right, then we would
adjourning
like
this
a
is going
hearing
to.
and scheduled the same day.
All right. Mr. Helton wants to say something, Ms. Underwood. We're going to set it for whatever date that is. Let me look that up.
Judge, the date that he was given was January 15th, but we had to move that date to January 13th at 1:30, and I have his new notice for that motion to terminate the PPO.
All right, so we'll set it for January 13th at 1:30 p.m. You're represented by an attorney, Mr. Helton. I can't let you speak directly to the court. I don't know what you want to say, and I don't want you to say anything that's going to harm your position at all.
Oh, I wasn't going to do that.
Mr. Help.
I have a video on my phone of the incident, and I've tried to submit it to show that he clearly is the aggressor in the situation, and he gets in my face several times.
Okay, I need you to stop.
Okay.
We're not here to discuss that right now. We're going to stop. Stop. We are not here to discuss that today. We will discuss that on January 13th at 1:30 p.m.
Could we discuss me getting my big toe cut off for frostbite?
No.
Okay. Okay.
I'm going to ask you to sit back in the gallery, and we will get you your notices.
Thank you.
Yes.
Sure.
Alan wants to know if you're having technical difficulties.
All right, Mr. Malero, you're ready to go with Ms. Julia Eichenberg?
Yes, Judge, I think we sent the plea offer, signed plea agreement over to you. He's done.
Ms. Underwood, Ms. Orwig and
Come
Mr.
see me when he gets
Torres,
up.
neither of them appeared, so I've issued bench warrants for them.
Are you talking to me, Judge? Sorry, I'm playing juggler today.
No, talking to Ms. Underwood.
Okay.
I can't hear what you're saying. Your mic's not working again. So Ms. Underwood, I issued bench warrants on Orwig and Torres. I think that's everything that I had for you. So if that's it, you can log out.
Where do I go speak to her
At the public defender's office. It's across 2 streets. It's on Front Street.
I'm sorry, can you hear me now?
Yes.
Thank you. I understood about the bench warrants, Your Honor. Do we still have Mr. Hodges?
Thank you.
I don't have a Hodges on my docket today.
Thank you.
What you just heard, it shows that you got it.
I'll check in the back. I'll go back down to the bottom of my chair. That way you're not sitting here. Yeah.
All you guys do is take a chain, you will be. Secret.
This is file 25-22141-FH, People of State of Michigan versus Melissa Juilliard Eichenberg. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Melissa Juilliard.
And Miss, you are Melissa Aline Juilliard Eichenberg.
Yes.
Mr. Malero, where do we stand with the case today?
Judge, there's been a plea agreement reached. There's been amended information filed. Miss Juilliard's going to plead guilty to count 4 embezzlement, 200 to 1,000, which is a 1-year misdemeanor. And I don't.
Okay.
And then the counts 1 through 3 will be dismissed at sentencing.
They don't have a signed advice of rights form. Has she signed one?
Judge, we got this plea offer and amended information late yesterday afternoon, and
I appreciate that, but the court rule requires me to have a signed advice of rights form.
okay, I don't have one. Miss Julie, are you able to come to the courthouse sometime today?
What was that?
Are you able to come to the courthouse sometime today?
Yes, I can.
Okay. What time would work for the court, Your Honor?
If she can be here at 1:30, I can probably do it then.
Okay. Can you be here at 1:30, Ms. Juilliard?
I can be.
Okay.
We will resume and do it at 1:30 then.
Okay, great. Thank you, Your Honor. I'll see you at 1:30.
Is Judge Olsever's court, could we get Michael Browder, please?
Your Honor, may I address the court?
Yeah, go ahead.
If Mr. Browder is the last case on the court's docket. I was going to request a brief bench conference for Sam and I to come up to the court to discuss the case. It's set for a trial next week.
He is not. I also have Mr. Gerhart, and I have a trial that was supposed to start at 10:30, so I don't have time right now to have.
Okay. Would it be possible? Is your trial going into the afternoon, Judge?
It's for the rest of the day.
Okay.
Isaac, I'll pop up if we can do Mr. Gerhart, I can pop up and talk to you about Browder.
I'm sorry.
You need to talk to him or just.
I'm sorry.
Oh, no, I didn't.
Yeah.
Please.
Sure.
It's Central Series Court. Could we also get Mr. We should be done. Thank you.
Judge, may I ask a question?
Yeah.
So on these advice of rights things, I mean, are we permitted to sign with their permission? Can we do fax? What's the requirement here?
Fax or email is fine, but I've got to have a signed one before I can take a plea.
And does it have to be in close relation to when the plea's taken, or how's that work?
I don't think the court rule says anything about timing, and I'm not aware of any case law. I think it's a recent amendment to the court rule, so I doubt there is any.
Okay, because some of these things get worked out the last minute, and it's not, it's just logistically not, convenient to make these things happen.
It's not convenient for me either.
No, I know. I'm not faulting anybody. We got to live within the rules. I just want to know my parameters because I have some, thoughts on how to make this a little less tedious.
Yeah.
All right, as long as there's no time requirement, I think I can figure it out. Thank you, Judge.
No problem.
Am I all set here, Your Honor?
No, we've got two more.
Okay, thank you.
All right, the gentleman at the jail, what is your name?
Michael Browder.
Okay, Mr. Malero, what did you want to do here? Did you want to speak to him or?
Yeah, Mr. Sneed and I were having some conversations. I think we're close to finalizing a resolution. But if the court's kind of jammed up, I'm not sure. I mean, is it possible to adjourn this over to tomorrow? If Mr. Sneed's available?
Yeah, if I could address that, Your Honor, I think we'd be fine just leaving the trial date down for now. Mr. Malero and you and I can confer regarding a resolution prior to then.
And then yeah, if I could do a breakout with Mr. Browder, that'd be great.
It looks like, Mr. Malero, that I am available at about 9 o'clock tomorrow for some time if you and Mr. Sneed wanted to have a bench conference.
That, yeah, I can do that, Judge.
Okay. All right, so we'll leave the current dates in place, and if you would like to talk tomorrow at 9 o'clock, we'll do that.
Okay.
Your Honor, if I could just say something on the record.
All right, no, because we're not on the record.
Okay.
So I guess let me start the record then. This is file 25-22414-FH, People versus Michael Deshawn Browder. We are here today for a final pretrial conference. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Salvatore Malero on behalf of Mr. Browder.
All right, and sir, you are Michael Deshawn Browder, is that correct?
Yes, sir.
All right, Mr. Malero, Mr. Browder had requested to say something directly to the court while we were off the record, and so I started the record so that we would have a record of what's going on. So I don't know what your thoughts are on having him address the court directly.
Well, my thoughts are that he shouldn't address the court, but he insists, so. Well,
What is it that you want to address the court about, Mr. Browder?
Your Honor, I spoke to Mr. Malaro the Tuesday before Thanksgiving, and he told me that he was going to file a motion to dismiss my case. And I even gave him a pre-written motion of doing extensive legal research. The People versus Merrick, it set a precedent stating that count 1 and count 2 of my charges are unconstitutional. And in his case, both charges were vacated. And both our federal and state constitution prohibit the government from enacting laws that abridge the freedom of speech. And also noted in People versus Kavisniga, true threats or serious expression.
Mr. Browder, I'm going to cut you off here because you're making a legal argument and you're represented by counsel right now. So
I do at this time. Sir.
Mr. Browder, I'm going to mute your device if you try to talk over me.
I'm sorry.
I'm, like it or not, I'm the person that has to control this hearing.
Mm-hmm.
And when I say stop talking, you got to stop talking. You are represented by an attorney. Your attorney speaks to the court for you on legal issues like this.
Mm-hmm.
So I'm not going to allow you to try to make a motion yourself. So as I said, we will leave the dates where they are. If Mr. Malero and Mr. Sneed would like to speak with me tomorrow at 9 a.m., I am available.
Yeah, I still want to do that, Judge.
Yes, thanks, Judge.
All right, Mr. Browder, you can let the officer with you know that you're done with court.
Thank you, Your Honor.
We've called the jail for Mr. Gerhardt. They have not brought him yet. I don't know where he is.
Judge, given you have a trial, I mean, I'd be okay moving this to 9 tomorrow as well, if it's possible. Sir, were you here for Mr. Gerhardt?
Yes.
We'll call the jail again and see what's going on. All right, thank you.
Right, so Judge Davis, is there anything going on with Gerhardt? And here, yeah, we were waiting for him. All right, thanks. And call for him.
Mr. Millar, do you need to speak to Mr. Gerhart?
Not necessarily, Judge. I think once I put on the record what we're doing, if he still wants to talk to me, that's fine.
This is file 25-22268-FH, People of State of Michigan versus Dustin Austin Gerhart. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Dustin Gerhart.
All right, and where do we stand with Mr. Gerhart's case today?
Your Honor, I'd ask for a brief adjournment. The basis is that Mr. Gerhart had previously been screened and accepted to recovery court, but then there was what I thought was a very large time lapse. To my understanding, that he does not need to be screened again. So I would just ask for a brief adjournment so I could finalize a resolution and then perhaps get him into recovery court.
All right, Mr. Sneed, anything that you need to address?
No, thank you.
I can set it for January 28th at 8:15.
That's fine, Judge, and if we get this worked out sooner, we can, would it be possible to bring him in?
You're welcome to call and see if anytime that we've got 15 minutes or so available, I'm happy to do it.
Great, thank you, Judge.
And Judge, he was just screened yesterday by CMH. He has been approved to go to Sacred Heart. So I am working with jail personnel. Bed should be available within the next week.
Okay.
Does his bond allow for that? I think his bond does, yes.
Correct. He was given 93 days on a contempt when she could be released after 45 to
Okay.
residential. So.
Okay.
All right. Anything else we need to address with this case today?
No,
Your
thanks,
Honor.
sir.
All right, Mr. Garrett, you can let the officer with you know that you are done with court for today.
Thank you, Judge.
Thank you.
Sorry this took so long, Your Honor. Apologize.
That's okay. We had a lot of people bouncing around today.
I think that's it.
Yep, we're all set.
All right, good luck. Thank you, Your Honor.
Have a good morning.